Morning, Chief.
Good morning, Commissioner Byrd. How are you, sir?
I'm good. How you doing?
I'm doing okay, playing catch up still.
Well, that's what you get for taking vacation, you know.
I know.
It's one of those darned if you do, darned if you don't deals.
Yeah, you take 2 days off and you fall 7 days behind. It's awesome.
Right? Yeah. Well, glad you're back. Glad you had a time off anyway with your family.
Yes, sir. I appreciate it.
Good morning, Jason. Hi, Steve.
Hey, folks, how you doing?
Fine, how are you?
Good morning, Commissioners. Good morning, Commissioner Hall.
Good morning.
Good morning.
Good morning.
Good morning.
Good morning.
Morning.
Mr. Chairman, before we get started, for those that are on the call, if you could please remain muted until called upon or until you're scheduled to give public comment or public comment during the hearing, I would greatly appreciate it. Thank you. Mr. Chairman, I believe you have all sitting commissioners, general counsel, others ready.
Okay, terrific. Just hang on till 9:30. I don't like to start early on the public.
Understood. Thank you.
So what? Just a minute to go here. Okay, just turned 9:30 on my clock. So let's start off with the, recitation of action at March 29th closed session meeting. We interviewed a candidate for the chief of staff position. I didn't inquire, what do we need to do with this particular item, Mike? Can you tell us?
Mr. Chairman, the Open Meeting Act requires that when the commission comes out of closed sessions, it should affirm for the record, in the sense of the minutes, that the closed session was the action, rather the items that were discussed during the closed action were limited to the matters that were the reason or basis for the closed session. In this case, it was not a closed session that the commission voted to go out of an open session. It was a scheduled closed session. So the Open Meeting Act requires that the commission affirm and recite for the record, in this case, the minutes, that the closed session was restricted to the limited personnel matters, which was the basis for the closure.
And so I will do that. We interviewed a candidate for the chief of staff position. That is the only item that was handled during that meeting. It was the only item that was discussed. Do we need anything further on that?
Mr. Chairman, no. The basis for that under the Open Meeting Act is that that statement will then be incorporated in the minutes of this meeting, and therefore that will suffice for purposes of the Open Meeting Act.
Okay, terrific. With that set aside, Mike, you get to say the pledge today.
I pledge allegiance to the United States of America, to the republic for which it stands, one nation, under God, with liberty and justice for all. I salute the flag of the state of New Mexico, the Zia symbol of perfect friendship among united cultures.
You do that almost as well as Commissioner Byrd. So now we've got consideration and approval of the agenda.
Mr. Chair,
Yes, Commissioner Hall.
I would like to move that we take item 21-00064 from the regular action items, part 1. It's item number Roman numeral 5 on our agenda, and move that on the agenda to before the public hearing, so we can discuss procedures going forward in that case.
And I will second that motion.
Okay, and with that, any discussion? And
Mr.
Mike, would you please take the roll?
Yes, Mr. Chairman, I just wanted to point out that if that is agreed on, that would not be part of the actual public hearing, is my understanding. So the court reporter does not need to transcribe that.
Correct.
So I would take the
Thank you for that.
roll. Commissioner Byrd,
Aye.
Commissioner Maestas,
Aye.
Commissioner Hall,
Aye.
Commissioner Vicente Aguilar,
Aye.
and Commissioner Fishman.
Aye.
Commissioners, the agenda as modified is approved by a vote of 5-0.
Okay, let me see. We've approved the agenda, regular action items. Well, I guess we're on to that item 2.
Okay, Mr. Chair.
Yes.
So I would like to make a motion based on several things, but primarily the report that we received from the joint report of the parties that we received very recently, in which the parties have agreed that it would be preferable to hold this hearing before a hearing examiner. And they've also agreed to how to handle El Paso Electric's fuel clause for the month of March. And so I am moving that we order El Paso Electric's fuel clause effective for their April 2021 billings to include their February fuel and purchase power costs, excluding the 6.8 million amount that's in dispute in this case. So that would result in a fuel cost factor of 0.0242 per kilowatt hour. Then I think, and I'm also moving that we send this case to a hearing examiner to hear the parties' arguments on both sides in a way that fleshes it out in a more orderly way than I think we would be able to proceed today, especially under our time constraints.
Mr.
So
Chairman,
that's my motion.
Commissioner Maestas.
just, I have a formal order that basically does what Commissioner Hall is recommending, which is adopting the proposed procedure as outlined in the joint report of the parties. I thought that Commissioner Hall's motion was going to be limited to eliminating the need for today's hearing. And so as a friendly amendment to her motion, if she could just limit her motion to vacating today's hearing, and then we can proceed to acting on my order, which was submitted by Russell. And I invite Russell to present at an appropriate time, laying out how we institute a temporary adjustment and how we proceed with resolving some of the issues at hand. So it's just a procedural issue. And perhaps if Commissioner Hall could maybe withdraw her motion and we can hear from Russell regarding my order, then maybe that could clarify for the other commissioners, how we can proceed, addressing what to do with today's public hearing and then agreeing in the way of a formal motion on my order on how to proceed going forward. And again, consistent with the recommendations by the parties in their joint report.
So Russell, please jump in here, and then I think procedurally we're all headed the same direction. So just guide us through the motions, and we'll get this matter disposed of.
Mr. Chair, I'd be glad to just adopt Commissioner Maestas' Commissioner Maestas's proposed order into my motion.
Which is fine. Let's go to Russell real quickly and just be sure we're dotting the i's and crossing the t's.
Yes, thank you, Mr. Chairman. Good morning, Mr. Chairman and Commissioners. Can you hear me?
Yeah.
Yes?
Yes.
Okay. So yes, I'm sorry that the proposed order by Commissioner Maestas, which would do the same things as the motion just made by Commissioner Hall. I just sent that out this morning. I'm sorry for that. You probably haven't had a chance to review it, but it adopts those same recommendations of the joint report. In that it would issue the temporary adjustment that Commissioner Hall mentioned in her motion, which would be to basically allow for February costs, which do flow as usual under through the fuel clause through into April billing, would flow through with the exception of the $6.8 million in incremental costs that are claimed by EPE in the motion. So the controversial costs would be set aside essentially. That would be the only temporary adjustment needed. And then the matter could be sent to a hearing examiner. Both of those items were in both Commissioner Hall's motion and also in Commissioner Maestas's proposed order, which I just sent out this morning. So they're really the same. And there shouldn't be a problem with doing either one. And then that would of course mean that the hearing would not go forward today. As said in the joint report, the parties were ready to just answer any questions that the commissioners had, but it probably makes more sense to just go ahead and send it to the hearing examiner anyway. And then the hearing examiner would be named by a later subsequent single signature order because I don't have a name of a hearing examiner yet. And that would really be it, except that I think one point of clarification is that because in preparation for this hearing, the commission had issued single signature orders, one of which defined who the witnesses would be for the hearing. And it was limited to 3 of the declarants and also defined who the parties would be to this hearing and essentially the case itself as just those who had filed the motion or a response. I think what the hearing examiner will probably prefer is that I include something in the order that says any orders that have already been issued by the commission defining the witnesses or the parties are null. So the hearing examiner can simply start procedurally where he or she will want to start. So that's what I would say, that the commission could vote on Commissioner Hall's motion because it really includes what Commissioner Maestas's proposed order was going to do. And I will just add that language. I'll take out any language that was in Commissioner Maestas's order, which referred to any hearing today, obviously. And I'll just include language that says the hearing examiner can start with a clean slate in terms of the parties and the witnesses. They could just start anew.
If we were to do that, Russell, I know some people probably logged on to give comment as part of the hearing. Would it be okay if they made a comment during the 3-minute public comment if they so desire?
Yes, Mr. Chair, you can handle that either way. If the commission wants to open the hearing just to have the court reporter transcribe some public comments, I think there is one public comment. I don't know, Isaac would know about this case in particular. But now that this isn't on for a hearing today, it might make more sense to just ask that person to provide public comment during the general public comment portion of the agenda.
Right, and there'll be an opportunity to get on the record, I hope, with the hearing examiner. Okay, very good. Russell, it sounds like we're good going with Commissioner Hall's proposal. That'll incorporate everything we need to do, including your modifications that you just described to the order, correct?
Yes.
Okay. So do we have any discussion or a motion?
Well, I'll second that, supporting Commissioner Hall's amended motion that it would incorporate most of my order with that modification that doesn't reflect that we had a hearing today, consistent with what Russell just said. So I'll second that.
Okay. Terrific. Any further discussion? Okay, Mike, please take the roll.
Commissioner Vicente Aguilar,
Aye.
Commissioner Fishman,
Aye.
Commissioner Byrd,
Aye.
Commissioner Maestas,
Aye.
Commissioner Hall.
Aye.
Commissioners, the motion passes 5-0.
So now procedurally, Mike, help me out. Do we need to go back to public hearing, or we've already nixed that from the agenda with this last vote?
My understanding is that the public hearing has been removed from the agenda by that vote.
Okay, terrific. Okay, we're on to introduction of special guests.
Mr. Chair, this
Yes.
is Commissioner Hall. I'm going to have to sign out for a minute. I've done something that makes it impossible for me to see the meeting or access my Zoom stuff. So I'm going to have to sign out and sign back on. Just so you know, I'll be gone for a moment.
Okay, thank you for letting us know.
This one's-
Any special guests?
Mr. Chairman, this is Jason. I do not have anybody signed up for a special guest today.
Okay, so with that, let's move to public comment. And Jason, someone who may not have signed up, but who had intended to make comment during the hearing, please, if you can, make them available. I thought I saw a couple of folks who might be interested in doing that before we started the meeting.
Yes, Mr. Chairman, in consultation with the Office of General Counsel, we had a Miss Sarah Gerson who was signed up to give comment on the case 21-00064-UT. And based on what I heard from the commission just a moments ago, we would accept comment during this portion of the agenda. So Miss Sarah Gerson, if you're available, please unmute yourself. And for your information and others that are giving public comment, we are live on YouTube and have limited public comment to 3 minutes unless the commission would like to extend that opportunity. Ms. Gerson?
Thank you and good morning. My name is Sarah Gerson and I'm speaking this morning on behalf of Prosperity Works because Prosperity Works is concerned about the possibility of EPE reaping windfall profits at a time when many customers are already facing economic hardship. Customers are relying on the commission to make sure rates are just and reasonable, which is a standard that's hard to square with EPE collecting millions of dollars in excess earnings as a consequence of last month's gas system crisis. I have no intention of repeating the strong arguments that other parties have already made about this case, but I do want to raise one additional issue that the commission should consider now that it's set a procedure for this case that will allow careful decision-making. Specifically, I want to alert the commission that would set a dangerous precedent to assume that EPE's gas imbalance penalties are recoverable fuel costs. FERC has repeatedly refused to allow generators to recover these penalties in its regulated markets because it doesn't want to create an incentive to ignore pipeline rules that are meant to protect gas system reliability. Just last September, FERC explained in docket ER 20-2360 that, quote, allowing generators to recover these penalties could jeopardize the reliability of the natural gas pipeline and transmission systems and is therefore at odds with the reliability benefits associated with allowing generators to recover actual fuel costs. So for all of these reasons, Prosperity Works urges the commission to stand firm against hasty decision-making, as you've already done, actually, now that you've taken that vote. So thank you. And going forward, remember that customers are already struggling under heavy energy burdens and should not face unjustified bill impacts. Thank you.
Thank you, Sarah. Anybody else? Jason?
Yes, Mr. Chairman, we have two more individuals that have signed up for public comment. I will call on Ms. Kimberly Martin. me confirm.
Hello, my name is Kimberly Martin. I don't have a comment on the El Paso issues, but I do have another comment on a PRC rule. Is it appropriate to make that right now?
Mr.
Yes,
Chairman,
it is. Go ahead.
Good morning. My name is Kimberly Martin, and my husband and I have made an investment in solar panels. I am making a comment about an adverse effect New Mexico PRC Rule 570.10, specifically Section 2, has on the owners of residential solar panels. Section 2 of that rule forces my utility, in this case, Jemez Mountain Electric Co-op, to purchase all of my rollover kilowatt hours on a monthly basis whenever the amount of rollover kilowatt hours reaches $50 or more. For us, that would be about 1,760 kilowatt hours. I was informed last year by John Reynolds that utilities have leeway in how they implement this rule. Jemez Mountain Electric Co-op has chosen to cash out on a yearly basis. Last April, they gave us $66.14 for 2,328 kilowatt hours of energy. We then turned around later that year and paid an extra $250 for electricity throughout the rest of the year. If we were not cashed out per the PRC rule, our energy costs over the summer would have been completely covered by our now X rollover kilowatt hours. I believe this rule as written is actually hostile, a little bit hostile to solar panel owners. I sent the commissioners of the PRC a letter regarding this issue, and I understand it's not good for the utilities to have rollover growing and growing and growing until it reaches untenable amounts, but at least leave the solar panel owners enough energy to cover their month of highest use. And like I said, I sent the PRC a letter regarding this, and I would appreciate a response sometime later when things calm down a bit. Thank you.
Thank you.
Mr. Chairman, we have one more signed up. Ken McDaniel, regarding the subject of the comment is dangers of change to 10-digit dialing, 988 dialing. Ken, if you could please unmute yourself.
Hear me?
Yes, sir.
Okay. I'm Ken McDaniel. I'm just a regular citizen. I put in because I saw in the paper the proposal to go from 7-digit dialing to 10-digit dialing, which looked like a bad idea when I first saw it and a worse idea when I thought about it some more. I recognize that you guys don't have the authority to order the federal government to get off of this idea. But I believe that if enough states told them what a bad idea it is, maybe we would get some attention. We've got thousands of little old ladies with necklaces that have a button that says, I've fallen and I can't get up. One of those is a friend of mine who has used it at least 4 or 5 times in the last couple of years. All of these things would have to be reprogrammed. They may or may not get reprogrammed successfully, or people may or may not remember that they need to reprogram them. We've got other security systems and such that use the phone system, which again may or may not get reprogrammed correctly. And we've got people running around. When I had a tragic instance with my iPhone and I had to buy a new one and re-enter all my numbers, I was complaining to my baby brother about that, and I had 100 and some, and it was a real mess. And he said, brother, I have 2,000. So, there are people out there, particularly people active in business, who have huge numbers of phone numbers that would need to be worked on. And in addition to that, I don't know that there's any good reason why the feds couldn't go to something like a 1-800 and then whatever number they want to use without interfering with our ability to dial a 7-digit number. It would seem that it would be an easy thing to remember if they say went 1-800-999. That would be an easy number to remember. Wouldn't take but a couple extra seconds for somebody, as opposed to where we are right now. I'm not sure whether there may be emergency numbers we use now that we might suddenly need to dial 505 in front of. I don't know for sure how that works. But the other thing is, I'm not sure that a national hotline as a primary hotline rather than a rollover is all that great an idea. If I were having my worst day ever and called the suicide hotline and Chuck Schumer picked up, that might drive me over the edge. And I'm sure Chuck would feel the same way if somebody from Georgia picked up his. You're more likely to feel like you've got somebody simpatico if you're talking to somebody who at least has an accent you recognize as being, from your state. So because of all those, I'm thinking that this rule is likely to cost more lives than it saves, and is likely to cost thousands, perhaps millions of hours of work by people who need to reprogram every number in their automatic dialing systems, whether it's on their phone or on some other device. If you got 2,000 numbers in your iPhone and you have to go back and do surgery on, the majority of them because they're local numbers that are set up as 7-digit, I think this is a really bad idea. And I would really like for the commission to write to the feds saying, we have had some input, we have discussed this, and we think it is a really bad idea, and request that you consider, going to another format.
Okay, well, thank you. I think we're coming up on the 3 minutes there.
Yeah, that's all I had.
Pardon?
That's all I had for you.
Okay, well, terrific. Thank you for the public comments. It always helps us to hear them. So for everyone who commented, thank you. And your thoughts will be carefully considered. I wanted to just real quickly also thank the parties at El Paso Electric for coming up with a very sensible resolution to a process that was being rushed. So thank you to all parties for getting together and coming to a good agreement on that. So now we're coming to a presentation from Nora Lindgren and Deirdre Howard regarding the SPS programs for catching up with utility bills.
Mr. Chairman, Commissioner Byrd, if I may, the presenters need to share their screen. I don't have a presentation myself, but unless they're just giving a verbal presentation, I can just leave the agenda on the screen. Nora or Deidre, do you need to share your screen?
Hi, yes, good morning. This is Nora Lindgren, and I can...
Give me 1 second, Nora.
Okay.
Give it a try now. Laura should have the ability to do that.
All right, 1 second here. Let me know if that's available for viewing.
Yes, we can see it. Thank you.
Okay, great. And I do want to thank the commission for the opportunity to come to the meeting this morning and share this information. As kind of the overview and the agenda indicates, what we are talking about today is the energy assistance that's available to the customers that we provide service to in the state of New Mexico, and also what we're seeing in terms of participation and impacts from the ongoing COVID-19 pandemic. And so I wanted to start by giving just a little bit of an overview. Our customers do have assistance available in the form of the Low Income Heating Assistance Program. That's a federal program. And we do have some income qualified requirements in terms of how customers can gain access to this. In addition to base income qualified assistance, there may be crisis assistance available for customers who are in a state that requires additional funding. And as we have gone through the pandemic, there have been multiple times when the federal government has provided increased funding. That's through the CARES Act, through the ARP Act, consolidated appropriations, really increasing and bringing federal funding going to the various states, including New Mexico's, to unprecedented levels to ensure there is funding to help with utility bills, including electric and gas. And what we wanted to really address today is that what we are seeing with our customer trends since the start of the pandemic has been an increase in the number of customers who are becoming both past due and would otherwise be considered eligible for disconnection in absence of the current moratorium, and the size of the balance associated with those customer accounts. The chart that I have displayed comes from a filing that we make monthly. This is our most recent filing with the Commission. But it shows that since November of 2019, we've seen a little over double the number of customers that we would expect eligible. And the average past due balance associated with those customers has also grown. At the same time, the number of customers that are receiving energy assistance grants through those low income assistance funds that we talked about is materially down. When we look at the number of customers who have received a grant this year versus those same customers who received grants last year, we're missing about 3,000 customers who received an energy assistance grant on their Xcel Energy account in the prior year that have not yet received a grant this year. Our funding is on pace to be equal to the fiscal year 2020. And our payment arrangements as well for customers who are not receiving assistance, but calling to set up plans to resolve their past due balance is also down when we compare it to prior years outside of the pandemic. And as we think through causes around what could be influencing the lower participation rates in both the income qualified programs and the payment arrangement programs, we believe that may be related to the ongoing moratorium and the lack of disconnection notices customers are receiving. We certainly are not sending those notices, nor do we have any intention of sending those notices without approval. And in the meantime, we are taking many steps to reach these customers. We've been in communication and collaboration with our peer utilities to talk about successes and strategies in addressing customer needs, how we can encourage customers to set payment arrangements, how we can encourage customers to seek the funding that is available to help clear these balances. We are providing regular outreach to customers in the form of both emails and phone calls, acknowledging the hardships of the pandemic and encouraging customers to contact us for resources and assistance and to discuss their balances if they have been impacted by the pandemic. And we do also have work underway in creating an additional funding source for our customers within the state. In our other service territories, we do partner with local Salvation Armies to provide an additional source of funding that comes from voluntary contributions of other customers, an energy share program. And really what we wanted to present today and what we wanted to make sure was clear was just that as the situation continues and as the impacts of the pandemic continues, we are seeing this impacting our customers. And we are seeing our customers get further and further behind on their debt. And we really want to make sure that the opportunities for them to apply for these assistance resources and the knowledge that we are available to set arrangements to help to provide resources if they don't have a knowledge of them otherwise is really, really important, and is going to be a very, very key piece in managing growing customer debt as we come out of the pandemic. I know I kind of ran through a lot of information in a brief period of time, but I wanted to make sure that we did share what we were seeing and find out if there were any questions, comments, or any other discussion that would be valuable as we think about this topic.
So commissioners, feel free to ask
Mr.
questions.
Chairman?
Yes. Go ahead.
Thank you, Nora, for that presentation. And I really applaud all of your efforts to help customers through this transition as we come out of the pandemic. The governor has rolled out an emergency rental assistance, actually emergency rental and utility assistance program across the state. They are handling the parts of the state that I believe excludes Doña Ana County, Bernalillo County, at least the unincorporated parts of Bernalillo County and all the tribal reservation areas. Is there any way that you can help inform your customers of this federal assistance program? It's an application-based program that's going to go live on April 5th. The only catch is this initial rollout of this type of federal assistance is for renters only. And so would you be willing to assist in notifying your customers with the understanding that your customer base is a mix of homeowners and other customer classes in addition to renters? So are you willing to do that?
Yes, we are definitely willing and are continuing to try to find ways to reach our customers to provide them information about these programs. And that does include proactive phone calls to customers. We've done pre-recorded messages that go out and just explain if you are a renter, if you have been impacted by the pandemic, we could do something like that in this area as well.
So you're, just one last question, your customer profile database doesn't ask whether they're owners or renters, or if there's a landlord maybe registered to that account, is that kind of a hint that the primary customer is a renter?
Yeah, we do have partial insight into our customer base as to whether they are renters or homeowners. We do not have full insight. So we do have the ability to get some incomplete profiles and to provide targeted communications, but we know it's incomplete. And so that does limit the scope of impact we would be able to have. We do have conversations with customers on the phone, and we do try to engage in proactive conversations. So as we hear things in those conversations, we do share the information. And we have made attempts to share broader general message to encourage customers to start that conversation as well.
Thank you so much. That's all I had, Mr. Chair. That's all I had. Thank you.
Thank you.
Mr. Chair.
Sorry, I had to unmute myself there. Go ahead, Commissioner Hall.
So Ms. Lindgren, I think I heard you were saying that the participation of customers in obtaining grants has decreased. Is that right?
It has. When we compare the number of customers, we've looked at the customers who received a LIHEAP grant in the fiscal year of 2020. Mm-hmm. And when we look at those same customers and which of them have received funding, 3,000 of them have not received funding this year. That is a fairly significant drop for us. There's always, we sincerely hope that when customers don't apply in the subsequent fiscal year, it's because they are no longer income qualified and they're in a much better place. But with a drop as significant as what we're seeing in the ongoing situation and knowledge of the economy, it's not likely that is what is a major contributor to this drop. We're just simply not seeing customers seek assistance, and we're not sure if that's a lack of knowledge of what's available or a lack of engagement in the process, but it is something that we are really trying to help increase.
Okay, my question is, I got the moratorium prevents you from disconnecting people until the time period is over for utilities, which I think is 190 days or something like that. Mm-hmm. But at some point, I think it's during the transition period where you can begin sending out some sort of notification that you're in a transition period. I guess what I'm getting at is once you are able to send out disconnect notices, can the parties apply for grants at that time? I mean, aren't they still eligible to get grants? And if you as you suggest, their motivation may be, or their lack of motivation in seeking these grants may be that they haven't been sent a disconnect notice. At a time when you may be sending a disconnect notice, are they not still eligible for LIHEAP? Could they not then obtain the grant funds at that time?
I can double check the expiration of the application period. It varies, and it has been extended in multiple areas. I think our main concern is that the longer we wait, the larger the balances will be. And so you are right, there will be a transition period. We will send notices, and at that time, we do expect to see an uptick in application. We have seen that in our other service territories. But between now and then, these balances will continue to grow, and the size of the grants is, it may or may not keep pace with the customer size of balance.
I understand.
I don't know if there was anything, Deidre Howard, if you wanted to add. I don't know if she's able to get her, her computer wasn't working a little bit earlier, but basically it is, yes, that is going to help. It's
Okay.
just between now and then there's a bit of a gap.
Okay, thanks.
Mhm.
That's all I have, Mr. Chair.
Okay. Other commissioner questions, comments? Okay, well, Nora, thank you so much for giving us the update. We know it's a tough time,
Definitely.
not just for customers, but for utilities as well, trying to negotiate this whole circumstance.
Yes.
So we appreciate any efforts and partnership to just get everyone back to normal as quick as we can. And thank you.
Thank you again. Yes.
Okay, we're on to approval of prior meeting minutes.
Mr. Chair, move to approve.
Okay.
Second.
Got a Commissioner Maestas and Commissioner Hall motioning in a second. Any comments from commissioners? Mike, take the roll.
Commissioners, this is a vote on approval of open meeting minutes for February 24th, 2021. Commissioner Hall,
Aye.
Commissioner Maestas,
Aye.
Commissioner Vicente Aguilar,
Aye.
Commissioner Fishman,
Aye.
Commissioner Byrd, Commissioner Byrd. I thought I heard something, but so commissioners, the open meeting minutes are approved by a vote of 4-0.
That's the last two.
Okay, on to consent action items. We've got 20-00239 UT, T-Mobile's petition to relinquish its Mobility Fund 1 eligible telecommunications carrier designation. And Russell, go ahead.
Wait, consent.
Yes.
Oh,
Mr.
I'm
Speaker,
sorry,
this is
Russell. I'm
consent.
sorry. It's
Yeah.
consent.
Mr. Chair, I move to approve the consent agenda.
And I'll second that.
Okay, thank you, commissioners. We've got a motion and a second. Michael, would you take the roll?
Commissioner Fishman,
Aye.
Commissioner Maestas,
Aye.
Commissioner Vicente Aguilar,
Aye.
Commissioner Hall,
Aye.
and I'll try Commissioner Byrd. Appears we do not have.
Aye.
Oh, there he is. Okay.
Yeah.
Commissioner, consent action items are approved by a vote of 5-0.
Dan, I saved you the trouble of reading them.
Thank you very much.
Yeah, you're welcome. Okay, we're on to regular action items. In 20-00125, in the matter of the application for American Medical Response Ambulance Service for an amendment to its certificate number 56829. And Robert, please take it away.
Mr. Chairman and Mr. Hearing Examiner, do you need to share your screen?
Yes, please.
Okay, bear with me 1 second, sorry. Mr. Hearing Examiner, you should have access to share your screen now. We'll give it a try.
Okay, I'm trying. Okay, is that up on the screen, the recommended decision cover page? Does anybody see that? Jason,
Yes.
is that up?
I do
Okay.
see it.
Thank you.
Wonderful. And thank you, Chairman Fishman and commissioners. As you know, I'm Robert Lennon. I am honored to present my RD to the commission, and it's my pleasure as well. Us hearing examiners are a bit deliberate and perhaps move a little bit slower than representatives of the public or of companies, so please bear with me. Also, I'm suffering with some allergy symptoms personally, and the medicines are just starting to work, so I'm sorry if you notice that. Okay, this RD recommended decision was drafted, if you will, after the suggestion that the commissioners, the hearing examiners include a summary with their RD. So I did include a summary with this RD. Personally, I believe my entire recommendation is a summary of what happened at the hearing and the testimony and those things and my considerations. So the summary is actually a summary of the summary, if you will. And the nature of any summary, almost by definition, is as you exclude things in order to summarize, it becomes somewhat less accurate. So there is the beginning of the summary on the screen. I'll literally go through that, and I might comment a little further with a little extra detail. And if there's any questions at the end of the presentation, I will certainly welcome those questions. So lawyers are taught not to just read into the record, but essentially that's what I'm going to do. Starting out, the American Medical Response Ambulance Service, known as AMR, and we refer to it as AMR because it's just easier to say through the hearing, is a large nationwide provider of ambulance service, and they are indeed large. They do business in New Mexico. They have a certificate allowing them to do business in Curry, Bernalillo, and Valencia counties right now. This case was all about expanding that authority. They had applied for an amendment for their certificate so that they could service the territory, including Santa Fe County, with a stationing point in Santa Fe. Notice of the application was published, which is required of our agency. It was published, and that gives any party who objects to file an objection. 4 ambulance services did protest the expansion of AMR's authority. They were Superior Ambulance Service, Inc., known as Superior, Bernalillo County Healthcare Corporation, which is known as Albuquerque Ambulance, and the City of Santa Fe, which runs the Fire Department Ambulance Service, and Running Bear Rescue, Inc., also known as Rocky Mountain. And these names obviously aren't new to the commission, but for the general public watching on YouTube, they may be. I'm going to scroll down a little bit. Most of this application process is controlled by Section 652A8 of the Motor Carrier Act. In my recommended decision, it's reprinted for convenience, and I've actually bolded the more important parts because it's a long statute. But it sets forth the requirements for issuance for a certificate of ambulance service, and for a amendment to a certificate, which is essentially requesting the same type of relief, the same requirements are required. Excuse my redundancy. But succinctly, and like I said, that whenever you become succinct, you lose perhaps some accuracy, but for the summary purposes, the applicant has to be fit and able to provide the service. The applicant has to comply with safety and financial responsibility requirements. The service to be provided will provide a useful public purpose responsive to a public demand and need, and the applicant has filed a tariff. They also have to pay a filing fee. So of these four requirements, please allow me to scroll down. Only the third requirement, and it was controversial. The third requirement was whether the additional territory will serve a useful purpose, responsive to a public demand or need. That was more or less the issue in the case. The issue was, of course, raised by the four interveners. The city of Santa Fe, interestingly, did not offer any testimony and actually sought to withdraw on the Friday afternoon before the hearing began that following morning. The other parties did not have an opportunity to consider the motion to withdraw. They didn't have an opportunity to respond, and I did not rule on that motion. I allowed the hearing to go forward without ruling on that motion. One of the other parties did actually move to admit into the record the testimony which had been pre-filed by the city of Santa Fe. The Santa Fe, I allowed that evidence to be admitted. It was an interesting twist in the case, so that's why in this recommended decision, because that motion had not been ruled upon, I recommend that the motion to withdraw be denied. Anyhow, moving along. Even more important for this particular case was not the requirements in order to have the expansion, but the requirements set forth under 65-2A-13. That's the section, and I'll skip to it. Let's see. I'll try to get down to page 9 so people who are not familiar with it can take a look at it. There it is, protests, objections, and hearings. The parties are entitled to a hearing. That's why we had a hearing, because of the protest. This case might have proceeded without a hearing. It would likely have proceeded without the hearing had there not been protests, because the essential elements were approved by our employees, the PRC employees. Anyhow, here's what happens at a hearing. You'll notice the applicant at that point has the burden of proving that that it meets the requirements of the Motor Carrier Act. The protesting carrier has the burden of proving, excuse me, there I do have a pointer, has a burden of proving all matters of fact pertaining to its full service operation, the burden of proving potential impairment or adverse impact on its existing full service operations. Interestingly, this is important. I did not actually bold it, but I could have, and perhaps I might have been more clear had I not only bolded it, but that I underlined it. The protesting carrier's proof should include, without limitation, a demonstration with reasonable specificity of the nature of the existing full service being provided, the volume of passengers transported, the economic analysis related to expenses and revenues of full service operation, anticipated economic, business, or functional effect upon the proposed service of existing provision of or rates for full service transportation within the full service territory. In other words, here's some important words: reasonable specificity, volume, economic analysis related to expenses, revenue. These are important words for me to consider when I'm hearing the case. Now I'll go back, pardon me, back to page 2. So there it is. There's what I just read, and you saw it in the actual statute, but I just restated it here in the summary. I might have summarized it. I bulleted it so that it would be easier to read. Moving along, AMR, the interveners and the commission staff presented evidence regarding the three major issues. The three major issues would be, because of the protests, would granting AMR's application serve a useful public purpose responses to a need or demand. It's not numbered, but 2, would granting AMR's application impair or adversely impact the existing full service operations? And 3, are the existing carriers providing continuous and adequate service? Like I said, there was a bit more to it, but for the summary purpose, that's what we can review. AMR presented witnesses, excuse me. I had a few things I wanted to add. The hearing was conducted on December 14th and 15th. It was a 2-day hearing. There were 8 lawyers involved. There were 8 witnesses provided testimony. There were 12 exhibits. You know, I could say this is only a certification of ambulance case, not to diminish the seriousness of it, but to the parties, it was actually a serious case, and it was clear from the testimony they were presenting. You've heard the words burden of proof, and this is a common concept for lawyers, and it's the real meat of what I do for a living as a hearing examiner. I watch very closely who has the burden of proof. That's simply the burden of proving the essential elements imposed upon them by statute or case law or practice or regulation. So who has the burden of proof, and what is that burden of proof? And in these type of cases, I'm not reading obviously at this point, from these type of cases, the burden of proof is by a preponderance of the evidence. By a preponderance of the evidence is a legal concept. Lawyers spend a lot of time figuring out exactly what that means by preponderance of the evidence, but essentially it means more likely than not. If you can imagine the scales of justice, the 2 scales, it's a tilting of not equal, but slightly more than equal. 51-49 would satisfy a burden of proof, for example. 49% would satisfy a burden of proof. So it's actually a minimal burden of proof. It's not beyond a reasonable doubt. It's not clear and convincing evidence. It's only by a preponderance of the evidence. So when I look at a case, I have to consider whether a party has satisfied its required burden of proof, in this case, which was by preponderance of the evidence. When I evaluate evidence presented to me, I have to consider not only the actual contextual evidence, what it is, the substance of the words, for example, or the document, in this case, the words. I also consider the way the words are presented by the witness. I also consider whether the witness has any type of bias. Typically, it's an interest in the outcome of the case. And the most common type of interest would be a financial interest, if you will. Sometimes we'll have a mother testifying on behalf of a son. That's a familiar interest. But then there could be, for instance, say an owner of a company. He has an interest in furthering the financial benefit to his company. And then we have not only the bias of a witness, but the basis, if you will, of the knowledge. Some knowledge is personal knowledge. 2 eyes, the witness observed with their own 2 eyes, and the witness is testifying from their own recollection. That would be strong basis of knowledge. If the basis of the knowledge is you just heard about it, or someone told them, well, that's the whole hearsay concept. But if the basis of knowledge is weaker than firsthand observation and recollection, the basis is diminished. So these are the kind of things I'm considering when I listen to these 8 witnesses testify and reviewed the 12 exhibits. Okay, moving along. Pardon me for diverging in a little bit there. AMR presented witnesses from a Santa Fe hospital. Remember, AMR is the party moving to expand their territory into Santa Fe. They presented witnesses from a Santa Fe hospital who testified that there is a need and demand for the ambulance service that AMR seeks to provide. Now, keep in mind, the Santa Fe hospital operates in Santa Fe County, but primarily in Santa Fe itself. The request is for expansion is not only in Santa Fe, but for Santa Fe County. The hospital intended to continue using the City of Santa Fe Fire Department for transport for acute, more serious cases. That's in fact one of the reasons that, well, we don't really need to get into the Santa Fe motion to withdraw, but that was resolved outside of the hearing. For interfacility transport, which is a type of transport at issue in this case, the hospital was less than satisfied with the service of Superior and Rocky Mountain. Remember, those are one of the 4 that had intervened. Rocky Mountain was no longer providing service, and the hospital, through these witnesses, testified that they were not happy, frankly, with the performance of Superior. That still leaves Albuquerque Ambulance. The hospital declined, with the exception of about 44 transports during a 9-month period, to retain Albuquerque Ambulance. That's the third. We've got Santa Fe. You've got the Superior and Rocky Mountain. Rocky Mountain's not providing. That just leaves Superior and Albuquerque. Then Albuquerque is wholly owned by a competitor, namely the other hospital. There are only 2 hospitals in town, and the other hospital owns Albuquerque Ambulance. It's literally a division of the hospital. The testimony of the Christus St. Vincent Hospital witnesses provided evidence that granting AMR's application will serve a public purpose responsive to a need and demand. Now, the reason this is, I mentioned all that burden of proof stuff and all the bias stuff and all the basis of the knowledge, is that these witnesses, AMR, the applicant, provided from Christus St. Vincent's, their basis of their knowledge was firsthand observation. Secondly, were they a biased witness? Did they have a financial, for example, or familiar interest, if you will, in the relief sought by AMR? No, they did not. So that made them particularly credible witnesses in this case. These 2 people in the positions of authority, by the way, with personal knowledge. The other thing that's important of these 2 witnesses is that they corroborated another witness, which was Miss Dunn. Miss Dunn was the witness for the Commission Transportation staff. And here, excuse me for scrolling. The witness for the Commission Transportation staff testified that AMR had satisfied all the requirements. That's why I said the hearing would not have been necessary had there not been interventions. They recommended granting AMR's application. So why? The staff witness testified that there is a need for additional ambulance service in all of New Mexico, including Santa Fe County. So Ms. Dunn did not have a financial interest in the outcome. But then I look at the other of the 2 forks, if you will, the 2 prongs of the fork, which I'm using to assess her credibility. And I looked at the basis of her knowledge, and I listened to her testimony, and I reviewed her testimony. And the basis of her knowledge was, I'm paraphrasing, but is a general knowledge within our department. And how does her department, she diluted it to the department knowledge, not just her personal knowledge. And the department knowledge was based on communications with people in the field as they conduct their business, as they inspect, as they talk to people doing applications, as they talk to people in the field, as they talk to the public, as they talk, she mentioned legislators, and she also mentioned hospitals. And that's a pregnant pause, because one of those hospitals was Christus St. Vincent. And when I had the Christus St. Vincent credible testimony, it fully corroborated the testimony of Ms. Dunn of the Commission's Transportation Division. We're dealing in 2 geographical scopes here, because we have the City of Santa Fe and the countywide application for countywide authority. And then we have yet another wider all of New Mexico concept, if you will, geographical concept or spatial concept. And the need for ambulance service is statewide, including Santa Fe, including the City of Santa Fe, where Christus St. Vincent says they need another provider. Anyhow, these are concepts that I had to consider when I made the recommended decision and reviewed the evidence. The interveners presented reasons why AMR's application should be denied. Of course, that's what they do. The owner, another pregnant pause, the owner of Superior contended that because Superior's prices for services are controlled, he depends on the commission to limit competition. This was his testimony. And that competition from another carrier will diminish his ability to remain financially viable. I could have read that a few ways. Now, I didn't examine him, but he's that close to the edge that one more competitor is going to take him under is one way of reading it. That's not exactly how I read it. That's what he said, but I read it in context as he didn't need anybody else to compete with. And that's why he was requesting that the commission deny yet another competitor entering his market. Then witness Casper, the chief of Albuquerque Ambulance, like I said, owned by the other competitor to Christus Presbyterian, contends that his company is ready to provide additional services, he stated that because during the previous year, Christus St. Vincent hadn't asked for them to provide the service. There's no need. Christus can just ask Albuquerque to provide the service. Well, there's a few faults to that. Number one, this case isn't just about Christus. This case is about countywide, statewide provision of ambulance service by AMR. The Christus testimony is certainly applicable to Christus, certainly applicable to, let's say, Santa Fe area where Christus serves, and it's certainly applicable to a lesser extent to Santa Fe County, which is the real issue before you, whether to allow service in Santa Fe County. As it expands from the smaller geographic to the less to the more diverse countywide, it's less important. But this testimony from Albuquerque Ambulance really was referring just to Christus, not statewide, not something another provider further afield within Santa Fe County. And the case is about Santa Fe County. Anyhow, I was not frankly convinced. Well, I was not convinced that when a competitor doesn't purchase a product from its competitor, that it doesn't need the product. I could expound on that. It's not in my summary, but if Home Depot should run out of screws, I would suspect they would buy them from suppliers of screws before they ran over the Lowe's and bought their screws from Lowe's. That's a bit of editorialization, but it's a way of thinking of the concept of a direct competitor purchasing products from each other. It generally doesn't happen in business, and there's a lot of reasons for that. But the fact that the testimony of Albuquerque Ambulance that Christus St. Vincent didn't purchase the product from their competitor was not terribly significant to me. Strangely enough, they did purchase on 44 occasions over a 9-month period, according to the testimony. They did actually use Albuquerque Ambulance. So they could have. It's interesting that they only used Albuquerque Ambulance for 44 of those times. The reason that was so significant is that Albuquerque Ambulance is the only intervener who actually satisfied the requirement, and I'm holding it for my purposes, who satisfied the requirement that the carrier's proof include, without limitation, demonstration of with reasonable specificity the nature of the existing service, the volume of passengers transported, the economic analysis related to expenses and revenue. They actually did. However, their projection, their analysis, their financial data was based on an estimate of 2,000 transports. And that that core of their economic analysis was based on a projection of one of the other, pardon me, one of the other interveners who estimated that 2,000 transports would be available just from Christopher St. Vincent as a result of Rocky Mountain no longer providing that service. He used that 2,000 figure and projected that they would lose about $1,200,000, something like that. So Albuquerque actually did provide the data. They were the only one of the interveners that satisfied that required specificity and reasonable specificity. However, like I said, I found their analysis not convincing, specifically because 2,000 is nowhere near, 44, which I converted into an annual figure from 9 months to an annual of approximately 60. So the actual usage was only 60 rather than 2,000. Keep in mind, during that year, Christus St. Vincent could have used a Albuquerque ambulance. They could have hired them for the 2,000, but they did not. They chose not to. And the fact that they chose not to is not probative, because the Albuquerque ambulance is a wholly owned competitor. So that was the weakness in the Albuquerque ambulance case, even though they presented the required financial data, and they were the only one to provide the financial data. So contrary to the intervener's contention, the existing carriers are not providing continuous and adequate interfacility service, with that one exception of the competitor. Rocky Mountain's authority is suspended. The relatively non-biased witnesses, the Christus Hospital staff, credibly indicated the superior service was less than adequate, and that was in their testimony. They mentioned they couldn't get a hold of them by phone. They found their billing was ponderous, and it was unsatisfactory, so it was not provided. And that AAS, that's Albuquerque, is a competitor of the hospital. This evidence was unrefuted. AMR's application to expand its service territory to include Santa Fe County with a stationing point in Santa Fe should be approved. That is my recommended decision, and I'll stand for questionings. And thank you for allowing me to digress a bit.
Any questions from commissioners?
Mr. Chair,
Yes.
I don't have any questions, but I read the entire recommended decision, and I think it's very well reasoned, and I would move to approve the order pending any other further discussion.
Well, I will second.
Oh, sorry.
Any other commissioner discussion?
I'm sorry, I skipped over general counsel presentation. I apologize.
Oh, sorry.
No.
Judy.
Thank you, Commissioner Hall and Commissioner Fishman, members of the commission. The proposed order in your packet would adopt the recommended decision in its entirety. And, Bob did express the issues in detail, and I stand for questions.
That's why we skipped over you, is because you adopted his order in its entirety.
Right.
We both apologize. You've got two commissioners who are in the doghouse here. Any other commissioner comments? Mike, would you take the roll?
Commissioner Hall,
Aye.
Commissioner Byrd,
Aye.
Commissioner, okay. Commissioner Maestas,
Aye.
Commissioner Fishman,
Aye.
Commissioner Vicente Aguilar.
Aye.
Commissioners, the recommended decision and order are approved by a vote of 5-0.
Thank you, Chairman and Commissioners. May I be excused?
Yes, thank you, Robert. Appreciate it.
Thank you.
Okay, so we're on to item number 5, 20-00205. The temporary moratorium on residential utility disconnections. A couple clarifying points. Commissioner Maestas, do you want to take this?
Yes, Mr. Chair, very briefly, as I mentioned in the last few commission meetings, a couple of rural electric cooperatives have raised concerns regarding the reporting requirements in our disconnection moratorium, specifically requirements to report all communications or attempts at communications made between the utility and the customer who was actually disconnected, and a summary of call notes or emails in order to express the circumstances surrounding the disconnections. So that my order basically says, rather than reporting this monthly information, my proposed order directs utilities to retain the information and make it available to the commission upon our request. The order also requires utilities to retain the information 365 days beyond the expiration of the disconnection moratorium and the transition period. I did consult with utility division and they have no objection to this proposal.
Thank you. Judy, do you have anything to add?
Commissioner Fishman, members of the commission, no, I don't have anything to add. The order just says exactly what Commissioner Maestas said, that they would retain communications or attempts at communications between the utility and the customer who is actually disconnected, and a summary of call notes or emails expressing the circumstances. And the record shall be retained for the 365 days. Obviously, the commission could change the 365 days and make it a shorter period.
Okay, any commissioner discussion?
Mr. Chair,
Commissioner Hall.
I just wanted a little clarification myself. I assume the reason that they were having difficulty was based on the volume, I'm assuming, of work, or I just thought it might be helpful to have a little bit more explanation in the order of the nature of the difficulty, just so it's explained. I mean, I appreciate that that must be the idea, but I thought it might not hurt to explain it more.
Yes, these comments came from the general managers of two co-ops. One was Mora San Miguel, and I believe the other was Central New Mexico. And the GMs basically said that it's already burdensome with the other reporting requirements, and they felt that this would be an undue burden on them and that they had no problems retaining the records. And one thing that we noticed too is they're just starting up in-person board meetings, and their agendas were chock full with a lot of issues surrounding the pandemic, the stress that the debt that they're carrying has placed on them, and their challenge to maintain seamless operations and basically keep their personnel without furloughs or laying people off. And so I think the idea that I got was that they are quite overwhelmed right now, and that is the last thing that they want to worry about. And so this, I hope I characterize what they're dealing with now, and maybe what we can do just to minimize that burden just a bit.
Well, I'm glad to know. I assumed it was something like that, but I think it might be a good idea to put just a little language in there about the crushing burden of the rest of the work that they have to do at the moment, or something, just to make it really clear. And
one thing too that they provided some feedback about was the high frequency of reporting. for this anyway, for this particular information. And so it was not just that they had to report it and submit it, but it was the frequency of reporting that was
Yeah.
burdensome to them.
Okay, that's a good point to make too, as well. And the implication is, to the extent we wanted to demand the information at any point, we can, of course. And I don't think we need to put that in there, but did we not hear anything like that from other co-ops? Does it vary among the co-ops? And in terms of how they perceive the burden?
Since you bring that up, Commissioner, I had a call with Kevin Gronwald with the Co-op Association.
Yeah.
And we were speaking about a different subject, but he did say that was, burdensome and so he did weigh in on the moratorium, and he just made a comment, an unsolicited comment, that the reporting requirements were burdensome for his members.
Okay. Well, I mean, I was just concerned about the fact that we had chosen to do that for purposes of transparency, and now we're just basically not doing it. And that's fine. I appreciate that they have a lot of work to do. I mean, a ton of work to do. I just thought we should explain it a little bit more. If you could maybe, I mean, I'd be glad to propose some language if you want, but it really is just a matter of a few adjectives probably about the level of work that they have to do. I would suggest that we add some language, that it's difficult given the overwhelming amount of work that has to be done now.
Sure, we can do that. Judy,
Yeah.
Is that possible?
Yes, Commissioner Maestas and Commissioner Hall. I was thinking of something that stated that the basis for the difficulty was the frequency of the filings required and the level of business that they are dealing with arising out of the disconnection moratorium.
Yeah, okay. I think that helps. And
So Commissioner Hall, I'm just following up on your thought about transparency. And, there is a difference between keeping it on file and submitting a report that we look at and that it's available, quite frankly, to the public as well. And part of me's thinking, gee, maybe the better course to take here is to say, instead of monthly, which I believe is where we are now, is submit quarterly the information, but continue to submit it. And Commissioner Maestas, had that been any part of the discussion that you had, or?
Well, the co-ops, and again, these are just two co-ops. If, that's not a good sample size, but it is some consistent feedback that I received. Even if we maintain the reporting requirements, but reduce the frequency of the reports, I'm sure that would be well received. But again, in inquiring with Utility Division, because I want to know is there real utility in this? Is there really a benefit to receiving this? And they concurred basically that perhaps we don't need to receive it, but that we can acquire it upon request. So I would defer to John Reynolds again, and typically I'm an engineer. To do this, I would feel better maybe if I heard from 4 or 5 or 6 co-ops and maybe an IOU. But certainly, I think it's intuitive that if we reduced the reporting burden, knowing that perhaps the information is not that beneficial, that it would be well received by all the utilities. And so I'm making some assumptions, Mr. Chair, but certainly I'm willing to hear from from John Reynolds in terms of his perspective on perhaps, keeping the reporting requirement, but reducing the frequency.
Mr. Chair, I think that's a good idea.
Okay, so John, are you on?
Yes. Good morning, Mr. Chair, Commissioners, Commissioner Maestas. Yeah, I'm here. I had a couple of conversations with Jonas about it, and we did not see a pressing need for utilities to report this information monthly, or even at all, frankly. I think that, again, from our perspective as a utility division, or working on cases and testifying, I mean, we do make frequent requests for information and discovery, or refer to information we may not have in our testimony. And if the utilities are okay with keeping the information, and we know the information available, I think that's the most important thing for the utility division. I understand Jonas had some conversations with Ryan at Consumer Relations about it, Ryan Jimenez, and I haven't spoken to Ryan about it, I don't believe, but I understand he was comfortable with utilities retaining this information. And he has more day-to-day contact with utilities about customer service issues, far more than we do with the utility division. So that's my perspective on it, Mr. Chair and Commissioners.
Thank you, John. Any other commissioner comments on?
Well,
Mr. Chair.
Commissioner Byrd.
Thank you. Well, I hadn't heard from a couple of co-ops prior to, and I brought it up in the meeting when we were discussing the need for this reporting on a monthly basis in the first place. And I had made the comment that, do we really need them to go through the effort of making a report and submitting it if nobody's going to be on our end reading them? And I still think that's an issue. These are very demanding requests, something that if we should need it, we want to have access to it. And I think what Commissioner Maestas is doing in terms of being able to go back and see if some actions were taken that shouldn't have been at the time. But as we said last week, the majority of the ops and IOUs are going to do their best to stay in compliance. So I'm just going to add that there's been more than one or two co-ops. So some other co-ops have expressed their concern over how much information we're wanting, and it's still down to, is staff going to go and read through all of that documentation that somebody's taking the time to prepare? And like Mr. Reynolds is saying, is that no, not unless they have a reason to. So just having it available upon request should be sufficient.
Thank you, Commissioner Byrd. Let's get Judy and then to Cynthia.
The only thing I want to add is that the order proposed by Commissioner Maestas does keep the monthly reporting of the number of disconnection notices issued, the number of disconnections actually made, and the number of subsequent reconnections made. That was in the February 3rd order. So it retains those monthly filings, and they are made on the same day as monthly filings that are required by case number 20-00069, which is 15 days after the expiration of each monthly billing period. So I don't know whether that factors into your discussion, but I just wanted to let everyone know that.
Thank you, Judy. Commissioner Hall.
Yeah, I was just going to say, based on John's testimony, and it's certainly supported by Commissioner Byrd as well. It doesn't appear that we really have the need we thought we did. We could also say in our order that we reassessed our need for the information and found that we don't need it, even on a quarterly basis, as long as we have access to this data, which they're keeping, something to that effect, because really it does sound like, it's a burden on them. And if we don't need to see it, we shouldn't be imposing it.
So I'm feeling fine with what's proposed now that I hear more, and thank you, Judy, for your input. And Cynthia, do you want to propose a friendly amendment?
Sure. Yeah, I would just propose that we include some language to the effect that we've reassessed our need for the information and found that it's not necessary given the additional burden that imposes on the utilities during this trying time, or something to that effect. I'm sure Judy can capture the language effectively.
So Judy, do you have that?
Well, I heard that Commissioner Hall say that the commission has reassessed and determined that as long as the utilities retain the information, we do not need them to file it, and that the basis for the express burden was the frequency of the required filing of this information and the high level of daily business arising out of the commission's disconnection moratorium.
Sounds good.
Commissioner Maestas, are you good with this?
Yeah, I'm fine with that, and I'll second the motion as amended, or
The
Thank you.
I'll
amendment?
second the motion.
Okay, so we have a move to amend and we have a second. Let's do a quick vote on the amendment and then we'll vote on the full. So Mike, would you take the roll?
Commissioner Fishman,
Aye.
Commissioner Maestas,
Aye.
Commissioner Hall,
Aye.
Commissioner Vicente Aguilar,
Aye.
Commissioner Byrd.
Aye.
The vote passes 5-0.
Okay, now I will move the order.
I'll second it.
And Mike, please take the roll.
Commissioner Maestas,
Aye.
Commissioner Byrd,
Aye.
Commissioner Hall,
Aye.
Commissioner Vicente Aguilar,
Aye.
Commissioner Fishman.
Aye.
Commissioners, the order passes 5-0.
Okay, on to item number 6, 21-00046, SPS's request for suspension of its fuel and purchase power cost adjustment clause, establishment of a regulatory asset, and approval of a surcharge, and a true-up mechanism. And Judy, please take it.
Yes, this matter comes before you again on SPS's filing for a request of a suspension of its FPPCAC, its fuel and purchase power cost adjustment clause, establishment of a regulatory asset, approval of a surcharge, which it later stated that it was not requesting, and a true up and variance. That was filed on March 4th and supplemented on March 5th. The commission issued an order on March 10th requiring SPS to respond, and they did. Subsequently, a motion to intervene was filed by the New Mexico Large Customer Group on March 24th. There are two proposed orders in your packet. Originally, I had proposed setting this matter for hearing on April 14th, similar to what was being done in the EPE case, which hearing was subsequently decided not to be held. After that proposal, which is still an option. The commission received a March 29th, 2021 affidavit of Staff Accounting Bureau Chief Gabriella Deschino. And based upon her affidavit, there's a proposed order accepting her and the Utility Division staff's recommendation of no hearing. What Utility Division staff stated as the basis for not having a hearing is that Ms. Deschino testified that and concluded that as required, SPS has demonstrated that its fuel and purchase power costs are significantly higher in the month of February due to the cold weather event. As required, SPS has demonstrated that its fuel clause is designed to have electric power generated and purchased at the lowest reasonable cost. She did recommend the commission consider whether SPS could have acquired gas at a lower cost or if there was any negotiation with producers. In conclusion, she testified that she did not recommend a hearing and she recommended approval with conditions based upon the affidavit and recognizing the short time frame. At this point, SPS was granted a variance already for its April billing, but this would be for beginning for its May billing. And I don't know, just to refresh your memory, SPS proposed amortizing over a 24-month period from May 2021 to May 2023, the excess costs, and therefore 1/24 of the excess costs would be in the customer's bills for that 2-year period. Therefore, the proposed order, alternative order, would be to grant New Mexico large customers motion intervene and grant SPS's request for a variance with the following conditions. First, SPS shall file invoices received from its power suppliers related to the costs incurred for the cold weather event. SPS shall provide proof of, if any, negotiations initiated with natural gas suppliers to reduce the cost of gas and the impact to its customers. SPS shall make monthly reconciliation filings of costs charged in relation to the cold weather event. SPS shall notify the commission immediately upon receipt of emergency aid, federal aid, state aid, county, non-governmental aid, shareholder, or SPP funds that SPS receives to offset the costs incurred for the cold weather event. SPS shall identify impacts of such aid to the balance of the invoices and the balancing account used to true up the costs of the cold weather event. The proposed order further requires staff to conduct a regulatory review of all the filings made in conjunction with the conditional approval of SPS's application for a variance and file a report of its regulatory review in this docket. Originally, staff had proposed 6 months. In the proposed order, I am suggesting 12 months because we may not have all the information we need in 6 months. And since the true up or the amortization period is 2 years, 12 months is halfway through that period. But obviously that's up to the commission. And lastly, the proposed order states that if after receipt of any documents set forth in the order and receipt of staff's report, if the commission determines that it should conduct hearings and or further investigate whether SPS could have acquired gas at a lower cost, whether and to what extent there were negotiations with producers to lower the cost paid for natural gas, or whether or not the utilities should share in the excessive costs that are being passed on to customers. The commission reserves its authority under Rule 550 to conduct necessary hearings or other proceedings to determine these issues, including but not limited to the issue of whether SPS should be ordered to credit back to customers any amounts the commission may in the future determine to be neither fair nor reasonable, which were paid by customers for costs incurred during the cold weather event. And I stand for question.
Commissioners.
Mr. Chair,
Commissioner Hall.
I'd like to move to approve the order as written. I think the conditions are very clear, and I think it's a good idea. I think it's a good idea to provide, a reasonable period of time for the company to pull this information together. And I take it staff is going to be reviewing this information as it comes in, especially, information about negotiations that were initiated with suppliers to determine whether or not they could have acquired gas at a lower price. I mean, it seems like stuff like that might take a little while to examine. Well, actually, I guess our staff had recommended 6 months and Judy doubled that time. And that seems like kind of a long time to have to go back over your old records. But I guess I would go with 6 months myself. But if Judy, I know you gave a reason, Judy, why you changed it to 12, but I forget what you said.
The reason being that first amortization period is 2 years, so it would be halfway through that period. The second reason is that a lot of SPS costs are dependent upon reporting from SPP, and I don't know when they'll get all that information from SPP.
Yes. Okay. Oh, yes. Right. Okay. No, I think that's a good idea. That's a good reason. That's true. So, okay. So, yeah, I think these are good provisions, and I think we do want to be careful and make sure that we are doing our due diligence, and this is the way we do it, to make sure that the negotiations had resulted in the best price for consumers. So, so I'll move that order.
I'll second that. So just to clarify, that no amendments, right? The order as presented. Okay.
Right.
I'll second that.
Yeah.
Okay, we have a motion from Commissioner Hall, a second from Commissioner Maestas. Any further discussion from commissioners?
Mr. Chair.
Commissioner Byrd.
Just for clarification, she proposed 2 orders. She has an alternative order. I assume that they're talking about the original order presented.
No, this is the alternative.
Commissioner Byrd, yes, I believe the motion was made to approve the alternative order. The original order was to not make a determination until after a hearing that would be set on April 14th.
Okay, well, I just didn't hear Commissioner Hall say alternative, so my apologies.
Yeah, well, I didn't say it right, so thank you for that clarification.
Okay, any further discussion? Mike, please take the roll.
Commissioner Vicente Aguilar,
Aye.
Commissioner Byrd,
Aye.
Commissioner Maestas,
Aye.
Commissioner Fishman,
Aye.
Commissioner Hall.
Aye.
Commissioner, the order is approved by a vote of 5-0.
Okay, we're on to item number 7. 21 Triple Aught 44, and the matter of application of Grady Martin Wind for approvals and authorizations for the location approval of the Grady Martin Wind Facility and associated Gentie line in Quay County and Curry County. Hans, please.
Thank you, Chairman Fishman and fellow commissioners. The matter comes before the commission on the application for location approval and right-of-way determination filed by the applicant Grady Martin Wind on March 2nd. The proposed order that I've put before you requires the applicants to post notice of the proposed location and sets deadlines of April 16th to post that notice. A 60-day period deadline of June 15th then for any protests and filing motions to intervene. Utility Division staff response by June 18th, and a hearing date, if necessary, of July 26th. NMSA Section 62-93 provides the commission with jurisdiction to approve the construction of any plant designed for or capable of operation at a capacity of 300,000 kilowatts. This section 6293K then indicates the commission must issue an order approving or denying the application within 6 months of filing of the application. So we basically have until September 2nd. We can approve the application without a formal hearing if no protest is filed within 60 days of the date notice. And if staff comes back and confirms that the right-of-way is less than 100 feet, as the application has indicated. However, I'm going to assign hearing examiner Christopher Ryan to this matter in case that is ultimately necessary. But based upon if interventions or protests are filed, this will set the hearing date so we can proceed expeditiously in that event to meet that September 2nd deadline. So with that, this is fairly straightforward. This just really makes the applicant start the process by posting the notice so we can proceed according to the statutory guidelines. So with that, I'd ask for a motion to approve the order as presented.
Thank you, Hans. Commissioners, questions and comments?
So moved.
I'll second.
I don't know how this vote's going to come out. Mike, please call the roll.
Commissioner Vicente Aguilar.
Aye.
Commissioner Fishman.
Aye.
Commissioner Maestas.
Aye.
Commissioner Byrd.
Aye.
Commissioner Hall.
Aye.
Commissioners, the order is approved by a vote of 5-0.
Thank you.
Okay, we're on to, thank you, Hans. We're on to communications with Chief of Staff.
Good morning, commissioners. I don't know that I've said good morning in an open meeting for quite some time. It's typically good afternoon, but glad to see it moving along just fine. Thanks for the time off last week. I know I still participated in the meeting, but it was useful time with my family. I actually separated myself from work for a little bit, so thank you. Even though the session is back and they are considering a couple of bills, it doesn't have any impact on the PRC, hopefully. But anyway, just a couple of items. Just quick update to the commissioners and others on the call that the Bochum building is continuing to be renovated for the tenant improvements. I actually have a meeting scheduled with a few other employees, including hearing examiners and Miguel from IT, to conduct a walkthrough at the Bochum building tomorrow morning. And so I think I'll have a lot more detailed information available if you have any questions next week, but things are moving along just fine. We did get the ACH from DFA, I believe, that was provided to the PRC for the first 3 months from the previous grant approval, if you recall that conversation. And so that'll cover the lease from April, May, and June of 2021. And then the operating budget will cover the lease moving forward. We do have a couple of other issues that have come up, and therefore the tenant improvements schedule has been delayed a little bit. We at the request of the agency, there's additional items that have been added as we've found and discovered issues in the building through construction. So it's likely we can probably start moving furniture in, still targeting April timeframe. And then we'll obviously phase employees back to the office in a safe and prudent manner. And I'll work with whomever in the future on that move. So just wanted to give that quick update. I know it's important to the general public. I know it's important to the employees at the PRC to get updated on our whereabouts. And I've talked to a couple of commissioners, and I think it'd be a great idea to have kind of like maybe a ribbon cutting ceremony or something at the new Bochum building and share that location with the general public, with the media. We can obviously have Sarah, our PIO, draft the news release that it's now official. We no longer work out of a PO box. We have an actual address. And so I'd even be willing to maybe escort those that are interested to see the new building and how the hearing room is somewhat replicated. And that's one of the issues that I'll have to elaborate on a little bit more next week when we find an actual final solution on how that's going to be done, as well as where we're going to be hosting our commission meetings in person in the foreseeable future, right? So I know those are things that are still lingering out there that we need to keep track of and on our radar screen.
Mr. Chairman?
Yes.
Just, Jason, if I could, since we're on the subject of the Bochum building, can you maybe put together a parking plan? Because I think in our last discussion, we can't accommodate all the staff that will have offices, plus we'll need parking for members of the public and the parties that come for hearings and such. So you probably already have one, and if so, if you could maybe share it, and then if you do have a plan, maybe we can. I think we had talked about this several months ago. Work with the city of Santa Fe on acquiring some additional parking passes. So, do we have a parking plan? Number one, and number two, if so, let me know if I can help. If we're searching for additional parking from the city of Santa Fe, either through the convention center parking lot or from Surface Street parking spaces.
Okay, to Mr. Chairman and Commissioner Restos, to answer that question, we have a tentative plan, not something that's actually on paper right now. I have it piecemealed together right now, but we do have a couple of options, and I have reached out to not only the city, but to also a private vendor in the vicinity of the Bochum building that would work with us and provide some type of arrangements for visitors, others that attend the hearing room. Let me just share with the commissioners now. One of the issues is going to be the size and capacity available of the hearing room at the Bochum building that we're trying to replicate. And so since that has become an issue, I have reached out to the General Services Division and have made them aware that, even though we have been cooperating and trying to come up with the solution on our own behalf, it's time to really, in my opinion, the dust has settled. And so we still need their assistance. We still could use their assistance in identifying other conference rooms or hearing rooms that are underutilized in all of the state-owned space, including the Capitol outside of session, right? And so I mentioned that to them, and I had a meeting with Secretary Ortiz yesterday, and I'm going to follow up with him in a couple of weeks and see if they've identified any areas. I know that they are still revisiting what is the future plans for the rooms at the PERA building. We even have the Apodaca Hall that I think the PRC is the only agency at that facility that it's ever used it in a all staff meeting or for some big public comment hearing, such as the San Juan abandonment case. If you recall, we used the Apodaca Hall for public comment. And so it's another underutilized conference room, a massive conference room for that matter. And I think with a little bit of money, we could really convert it into being a standalone hearing room, commission chambers if necessary. And so I've relayed that message over to the General Services Division. They're very well aware. It sounds like they're willing to work with us and support whatever the PRC needs are. And so, you know, realistically, I even told them, you know, in 2 years, the commission for the most part becomes part of the executive because they're appointed by the governor. And so you would think that they would provide us with that type of support in the near future.
And then, Mr. Chair, Jason, just one last suggestion. We talked about this many months ago about the possibility of using the Santa Fe Community Convention Center space. And the reason why, you know, it's only a couple of blocks, not even a couple of blocks away from the Bochum building, but it could provide convenient parking in the parking structure, the underground parking structure at the convention center. So I don't know how far along you are in looking at other venues, but I think that could potentially be a viable one for us.
Mr. Chairman, Commissioner, absolutely. That is one of the top 3 locations. If you recall, I also had mentioned the PERA building and their facility, state-of-the-art facility, was also somewhat made available to us. And obviously, we'll have to continue those discussions as the road goes, as we continue to address and return to work plan, right? So how we do it, when we do it, where we do it. The good thing about it is that, you know, the commission has flexibility in their meetings. The hearing examiners may not so much as far as schedule goes. And so if they'll probably be more critical in having to schedule a location and time because those meetings are announced well in advance. Whereas the commission meetings, you know, we notify the general public and other stakeholders of the time and location by Friday at 5. So there's a little bit more flexibility in the PRC, in my opinion, commission meetings than there are the hearings. Because those are pretty much set in stone. So that is something else we're taking into consideration as we come up with and identify multiple locations. Commissioner Byrd has also been adamant and helpful about using the City of Rio Rancho facility. And we also hosted a commission meeting there many moons ago, it seems like, because of COVID. But anyway, they have another state-of-the-art facility that's been made available by the mayor himself. So I've identified several facilities, locations. Hopefully, when we return to normal operations, the commission will continue to consider hosting meetings in your respective districts as well. I think that was something that we were trying to accomplish, but then, of course, with COVID, all of that kind of got tabled.
Thank you.
Mr. Chairman, one other item, I just wanted to relay a message to the commissioners that I think several of you have already worked with our PIO, Sarah Valencia, and I think she's been very responsive and is catching up rather quickly. And I know the media and without a PIO, a permanent PIO for that matter, historically they've been contacting your offices. But I spoke with Sarah yesterday, and we just want to extend the resource to your offices. If anybody reaches out to you or you have any additional needs, if you want to maybe just refer them to Sarah to initiate the communication, I just wanted to relay that message. I know it's easier for the media or general public to reach out to a commissioner's office directly rather than going through the PIO. But if you wanted to put some formal process together, you know, I believe we have a good candidate that can accept that responsibility and be a good liaison between you and other stakeholders or medias that inquiring about any cases or administrative responsibilities, legislative matters, what have you, whatever the topic or subject may be. I'm just offering her services, extending her services. I don't even think I need to explain it to you all. It's there, you know, it's available to you. So, and then one last item, Mr. Chairman. Since I began with the PRC, I think the commissioners have been grateful in recognizing spring leave during the Easter weekend and Good Friday and whatnot. And I would request and recommend that the commission consider approving 4 hours of admin leave for this Friday, which is Good Friday, like we historically have done for the PRC staff, and in recognition of all the hard work and dedication that they've made.
I support that.
Yeah.
I'm okay with it.
Commissioner Byrd, I support it too. Is that something we need to take a formal vote on?
I don't think so, Mr. Chairman. I would defer to OGC, but historically, I don't think we've taken it. It's just a communication between me and the commissioners.
Michael? Michael?
Yes, I said that's correct.
Okay, good. Thanks.
Mr. Chairman,
by the way,
that's all I
Sarah,
had.
I want to make a comment. Sarah is sending out those daily press clippings, if you will. And boy, for a newcomer, she's doing a pretty good job of picking out relevant stuff. And I just wanted to thank you all. Thanks, Sarah, for getting that done. And it is helpful. So.
Mr. Chair, I also want to pitch in there and say thanks very much to Sarah. And I also appreciate her press release writing style. It's just really good. And I'd say she really shines among the PIOs we've had. So I'm glad she's there.
Thank you very much, Mr. Chair, Commissioner. Thank you.
Okay, we're going to go on to communications with General Counsel.
Nothing
Mr.
today.
Chair. Oh, good.
But Commissioner Byrd, wait for Mike to say he has nothing to say.
Well, I actually have a question for Jason.
Oh, okay, go ahead.
Sorry about that. So some people have expressed some concern about the environmental conditions in the Bochum building, problems they've had in the past. What kind of inspections have been done to ensure that the health and safety of the employees is being taken care of?
Mr. Chairman, Commissioner Byrd, I've received some reports from the landlords that were conducted while the Santa Fe County was occupying the building. But in addition to that, that's kind of the purpose for tomorrow's meeting is we're going to talk about the final building inspection and also a fire department, fire marshal inspection that will be needed post-construction of the tenant improvements. I've shared those reports and Danielle has assisted me in asking questions with the oversight agencies such as the Environment Department or Regulation and Licensing Department, whoever may have records or concerns. That has been brought to my attention as well. And so it's lingered around. I've been trying to address it, but at the end of the day, what we are going to have to do is figure out some type of final building inspection post-construction to identify if items such as asbestos or mold is even present. I think those are the two items that have been brought to others' attentions and concerns. Keep in mind the way this building was built. It sits on top of a restaurant, like a portion of it does. And I think there have been complaints made of the smell inside of these buildings, hence the reason for the air quality sampling and reports that were provided and conducted. There even was one of recent, I think I had them do one back in February 2021. And so I'm aware of it. I think at the end of the day, like I said, we just need to get a final building inspection done, a thorough building inspection done prior to moving in.
Thank you, Jason. I knew things were going on, but I just wanted to get that public that it's being looked into and taking steps to ensure safety.
Thank you. Yes, sir.
Any other questions for Jason? Okay, communications with, well, wait, first General Counsel. Mike, I almost skipped over you again.
Oh, I already said that I didn't have anything today.
Yeah, sorry, Mr. Chairman. I thought he already answered you without asking the question.
So we're on to communications with commissioners.
Mr. Chairman,
Commissioner Maestas.
I had just one issue with this emergency rental and utility assistance program going live on Monday. I'm planning on perhaps drafting an order requesting utilities to maybe develop a bill insert directing their customers, obviously if they're renters, to contact, or visit the website of www.renthelpnm.org, just encouraging them to seek this assistance or apply for this assistance, because I believe it will benefit the utilities. Now, they may do it on their own, but I think if you leave it to their discretion, who knows what kind of outreach they'll conduct to encourage their customers to seek out assistance through this program. And there's already a follow-on program with a significant amount of additional federal funding under the American Rescue Plan. And so this current emergency rental and utility assistance program it's going to be sustained through additional funding. So this could be, a worthwhile effort, but I just want to let my colleagues know that I'm considering that. Now, I do understand that most utilities don't differentiate their customers as renters and homeowners. And so is it a waste? Well, I can't clarify right now, but what I'm hearing is that the American Rescue Plan funding doesn't make that distinction anymore. The assistance would be available for homeowners and renters. And so, which is good news. And so this effort may not be done in vain if we order or require utility companies to put a bill stuffer in there to encourage their customers to seek assistance, assuming that they're eligible.
That's a good suggestion. A couple of issues arise for me, and Joe, maybe you have the answer because you're the one who's been bird dogging this, and thank you for doing that. Is one, if it's just an item on the typical information sheet, that's not going to be real helpful because those don't get read. So it seems to me if you're going to do it, you need a separate sheet of paper that goes in there that's really bold. And we would want to specify that. The second thing that I'm wondering is it part of the state's administrative budget that they're going to be doing some separate advertising and promotion of the availability of this program?
Yeah, what I'm hearing, and again, this is a fast developing program because of the state's desire to roll this out. They need to obligate about 2/3 of the $170 million by the end of the federal fiscal year, which is September 30th of this year. So they're under the gun to kind of get this out the door. And I think the feds have agreed to extend the availability of the funding if they can achieve that level of expenditure, the 2/3 obligation by the end of the federal fiscal year, that they would extend the availability through the end of the calendar year. So there's a sense of urgency. And what DFA had shared with me preliminarily, that they were going to award a contract through tourism to actually promote this program. But this was shared with me several weeks ago. That may have changed, but that was the intent. And there is an amount of that money that can be spent for administration. And I would assume that such a marketing contract would be permissible administrative expenses to implement the whole emergency rental and utility assistance program.
So I, for one, would appreciate if we, put together some kind of order to do exactly what you're talking about, because it's something that's been on my mind as well. So.
Okay, that's all I had.
Okay, other commissioner comments?
Yeah, Mr. Chair.
I'm going to go. Cynthia was first. Go ahead, Commissioner Hall.
Well, I was just going to say, I think it's a really good idea. I think it's well, I guess it depends on where you live, but there are certainly a lot of renters in my district. And I don't think it would be a waste to put some sort of, it wouldn't even have to be a full page piece of paper, but as long as it's something that's noticeable, some sort of notice. But I think it's really important to do everything we can to get the word out about this kind of money being available, this kind of assistance being available. And I think you want to target people who are interested in it. So people who get electric bills are the ones, well, they're handling their bills who would be most focused on it, I think. So I think that's a good idea to put a stuffer in the envelope.
Who, I heard another
Yes.
voice. Was that Commissioner
Yes.
Byrd?
Yes.
Yes.
Go ahead.
Just another perspective. Keep in mind that whatever we require them to do in bill stuffers, they get to automatically get reimbursed by the ratepayer. SPS to show that they have a fairly robust effort to reach consumers to try and help them get their bills paid, and actually admitted to or said that they would add additional information that Commissioner Maestas asked if they would put in there. And so they're doing that on their own. So maybe we can just see if that isn't adequate before we go and require it, so that reimbursement isn't guaranteed by the ratepayer.
So Commissioner Byrd, my one thought on that is, given the quick time frame, are we going to have a chance to evaluate whether it's effective, or should we just kind of be sure make sure we're getting the word out up front? So I don't know the answer to that, but
Right. And that's good. I understand it, but it's a catch-22. The whole point is to help ratepayers, and yet we're gonna charge you a little bit to help you out here.
Good point.
Mr. Chairman, if I may, I want to be cautious and not require the specific information about the rental assistance, because if there's a follow-on program that could be under a different title, then we're reacting again. So my hope is the state is going to come up with some kind of central clearinghouse toll-free number, not just for this emergency rental assistance program, but the follow-on through the American Rescue Plan. And so I would want to include some general information, but yet specific contact information that they can reach, right? That they have to inquire about these, not just the emergency rental assistance program, but the follow-on through the American Rescue Plan.
right. It seems kind of obvious, but it certainly couldn't hurt, I guess, if we sent a note on up to the governor's office and the appropriate agencies, saying be sure to include utilities in the communications that you send out regarding relief, pandemic relief. And maybe we can pull together something along those lines, if that makes sense.
Yeah.
And yes, I guess since you brought that up, Mr. Chair, I still have to recognize our staff, Isaac, Sarah, Tim Martinez, a bunch of folks that helped not just update the list of the regulated entities, electric and gas, but telecom providers, because as you know, we are providing assistance to DFA to ensure that our regulated utilities are registered vendors through the state's share system. So there's a big push right now to get utilities, not just the regulated ones, but the unregulated municipal and maybe county utilities, to submit W-9s. That way they'll be in the vendor list. And I would think that the state, once they get all these vendors in there, that they would be sending information to the vendors as well, which would be all the utilities, right? That would stand to receive direct payments on behalf of their customer applicants.
Okay. So if the commission's okay with it, I can just quick follow up and get something drafted for you all to look at that we can send to the governor's office. Okay, anything else on that topic from the commission? Okay, and I'll make, on communications with commissioners, you all may be aware that I've been without an assistant for a couple of weeks now, but we've had an offer accepted. I'm really excited about. I won't announce the person until the start date because I'm just that cautious. But anyway, we look like we're set up for April 12th. They bring great qualifications. The person is an attorney who has worked specifically on regulatory and utility law. So I think he'll be a great asset to all of us. And when he comes on board, I'm going to encourage all commissioners to feel free to take advantage of his expertise. So
Be careful, Mr. Chair.
well, you're the one I'm most worried about.
That's very good news. Congratulations. I'm
So
glad.
anyway, that'll be nice for me. I'll tell you that.
Yeah.
Okay. Any other communications with commissioners?
Mr. Chairman?
Yes, go ahead.
I'm not a commissioner, but this is Jason. And before the next agenda item, I just wanted to remind the commissioners, and I should have done so during communications, that you will exit this Zoom meeting and log into the Zoom information that was provided by Mr. Isaac from OGC when you go into closed session.
Mhm. Okay.
Okay. Well, with that, I think we're on to executive closed session.
Mr. Chairman.
Yes.
I move that we go into executive closed session pursuant to NMSA 78, Section 10-15-1, Print H and 2, to discuss limited personnel matters, to specifically discuss regarding the Chief of Staff position.
I'll second that.
Okay, we've got a motion and a second. Mike, can you take the roll?
Commissioner Byrd,
Aye.
Commissioner Maestas,
Aye.
Commissioner Vicente Aguilar,
Aye.
Commissioner Hall,
Aye.
Commissioner Fishman.
Aye.
Commissioners, the vote is 5-0 to go into closed session.
Okay, so I'm going to give 10 minutes till we start closed session. And so 11:55. Does anyone need more time than that? Okay, so we're good. 11:55. We'll get back in closed session. Thank you.
Thank you. Mm.
Can everybody hear me?
Yeah, Jeff, we can hear you. I see Commissioner Maestas is also on.
Present and
I'm here,
accounted
Mr.
for.
Chairman.
Commissioner Vicente Aguilar and Commissioner Hall, are you here? We'll give this a second. Commissioner Hall, please let us know when you come on.
That's an interesting assumption.
Yeah, it's kind of backwards. It's like when you get on a plane and you read the emergency instructions, and it says if you have not read these instructions, or you must read these.
Right.
Kind of funky.
Yep. Maybe we need to go into a chant like a basketball game or a rock star concert where everybody just starts chanting Hall, 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 Hall.
Get over here,
Come
Hall.
on. Come on, Commissioner Maestas. That was funny. You could crack a grin. There we go.
Commissioner Byrd, you're nothing but funny.
Uh-oh.
You know what? If you can't crack a smile every now and then and try to enjoy it, it becomes mundane and miserable. And so I try to keep it light, and because we're dealing with serious issues that affect people's lives in many ways, and including our own. And so sometimes we just need to laugh and enjoy a little bit of life, so we don't become miserable and regret or hate the job we're doing.
The sense of humor helps.
Since you brought up job satisfaction, I'm having a great time. I'm enjoying the heck out of myself. I really am.
Well,
good. Well, why are you scowling at us all the time?
It's only when you talk, Commissioner Byrd.
You know, I wonder if Mr. Lennon is still online. I bet he's back to work. But I wanted to comment about his pregnant pause. You know, that's a comedic line. You get into a joke and you have this pause for the punchline to help build an anticipation. And I thought it was interesting that he used a comedic line, pregnant pause, during his presentation. And then his punchline was not, something we really got excited about.
Jason, have you heard anything from Commissioner Hall?
I have not, Mr. Chairman.
Mr. Chairman?
I'm right here. I just joined. Sorry.
Oh, okay.
I just called her.
Yeah, thank you.
Terrific. Okay, I think we got all 5 commissioners on board. We just have had our executive session. We discussed only the issue of the chief of staff position. And we're now ready to come out into our regular open meeting session.
Mr. Chair?
Yes.
I'd like to make a motion to come out of closed session and back into open session pursuant to the citation in the agenda.
And I will second. Commissioner Vicente Aguilar? Did you have a comment?
I second it.
Okay, great.
I second it.
We've got a motion from Commissioner Maestas, a second from Commissioner Vicente Aguilar. Mike, would you take the roll?
Commissioner Byrd,
Aye.
Commissioner Hall,
Aye.
Commissioner Vicente Aguilar,
Aye.
Commissioner Maestas,
Aye.
Commissioner Fishman.
Aye.
Commissioners, the motion to come back out of closed session into open session is approved by a vote of 5-0.
Okay. So we're on to item 16, potential action regarding offer of employment for Chief of Staff position. And I'm going to turn this over to Commissioner Maestas.
Thank you, Mr. Chair. I'd like to make a motion to offer employment for the Chief of Staff position to Mr. Wayne Probst at an annual salary of $150,000 and with a report date of April 19th. He'll be reporting to you at 8 a.m. on that report date.
I'll second that motion.
Mr. Chairman?
Yes, discussion.
Under discussion, I just want to say a few words about Mr. Wayne Probst. Wayne will be joining the PRC. Well, his most recent position was with the Senate Finance Committee, where he held the title of Chief of Staff. Prior to that, he served as the Executive Director at the Public Employees Retirement Association of New Mexico for almost 9 years, where he developed comprehensive pension reform legislation in 2013 and 2020. Prior to that, he also served as Executive Director for the New Mexico Healthcare Authority. Wayne is well known in New Mexico government and brings with him a number of accomplishments such as reducing PARA's unfunded liability and significantly improving the long-term solvency outlook. With his long-running management experience and history of public service, the PRC expects to benefit from his breadth of experience. It's with great pride that I make this motion. But just to finish my discussion, Mr. Chair, Mr. Jason Montoya has served admirably as our acting Chief of Staff, and I commend him for serving in several capacities, but over the last several years, this agency has dealt with a lot. An office eviction, a hiring freeze, a budget veto, a substantial budget veto. And so I just commend him for really moving this agency, navigating it through these rough and choppy waters. And so I just want to thank Jason for his service and also call on him to assist Wayne in his transition as he works his way into this new position. That's all I had, Mr. Chair.
Thank you, Commissioner Maestas. Shall we go to a vote, or does the Commission want to take on any further discussion?
Mr. Chair.
Mr. Chair.
Okay, Commissioner Byrd, you first.
Thank you. I was noticeably absent in comments about our current Chief of Staff during our executive session, and because I fully intended to do it publicly. Jason has done not just a good job, but an exceptional job as Chief of Staff. He's done a fantastic job of helping the morale of employees, moving this agency in a more positive direction. He's known all along that somewhere in front of his title was the word acting. And I encouraged and tried to get him to take the job full time. But I couldn't argue with him because his statement was, well, I want to make sure and ensure that I have the ability to provide for my family. And he's actually he just doesn't have a whole lot of years with the state agency, and if he was to be let go in an exempt position, he'd really be in a bad spot. And so I couldn't argue with him because one of my mantras here has been family first. And so I never really pushed him on it, but I've always asked him, and he understood where my position was with him, that I would be in 100% support of him being our Chief of Staff. And I know there's a lot of staff members who have come to respect Jason over the last almost 2 years that he's been here as acting. And they're actually worried that the future may not be as good as the present. And we all a little bit nervous about change. But I believe that Mr. Props brings a great skill set. I think it will be a good addition to this agency. I think that given some time, and if our staff will just give him a little leadway and know that there is going to be some changes because he has his management style, but to work with him, that in the end, this will also continue to be a better and greater agency. And so I want to thank Jason for his unending hard work and professionalism. When we hired him, he was just a pipeliner in my mind. I didn't know a lot about him. But he's just been an exceptional chief of staff, and I wanted to thank him publicly. And I also want to just let Mr. Props know, should this vote be in the affirmative, he's going to have some really big shoes to fill. But we here as commissioners would be 100% on board to help support him. And I believe the current chief of staff, outgoing Jason Montoya, will also willingly help him should he just be willing to ask for a little help when needed. Thank you, Mr. Chair, for the time. I appreciate it.
Thank you, Commissioner Byrd. Commissioner Vicente Aguilar.
Yes, Mr. Chairman, thank you very much. At the beginning in January, the very first open meeting, 2021, Mr. Chairman, you indicated that every commissioner is going to be treated equal. And I hold you to that standard every day. And I'm not going to go into detail on that end, but this is a 5-member commission. All 5 commissioners are elected from different districts. So we have an equal opportunity when we have the time to express how we feel about our current chief of staff. He has done as what Commissioner Byrd has indicated. He went through so many obstacles. In January, February, and March of 2020, there was a legislative bill to dismantle us completely. Our chief of staff, Jason Montoya, worked through the negotiations. He talked to the lawmakers, and we were able to survive. And from there, we all saw the downfall, action after action. But we are still here today, approving utility bills, approving analyzed recommendations from our hearing examiners. We're here as a team. We are functioning without an office. Our hearing examiners are using a drop box for a public hearing to build up their case. These are all the challenges that we have faced within the last 2 years, but we are not going away. We are still abiding by the law. We are still abiding by the Open Meetings Act, and our staff members just follow through professionally, and they are still going to do that for the remainder of the Public Regulation Commission. And I'm proud. Today, I'm very proud to be part of the team. And thank you very much, Mr. Chairman, for allowing me to speak. But nothing is going to go away. But Jason has pulled it. He has pulled it. And today's decision is nothing regarding his personal performance. Thank you very much, Mr. Chair.
Thank you, Commissioner Vicente Aguilar. I'm going to just add a brief comment about Jason. If I had to pick one word to describe his attitude and his tenure, it would be fearless. He walked into a big job when there was lots of chaos and there was no challenge that he didn't stand up to. And, you know, I've seen him pursue all of the things that we needed to do in response to outside forces that just at times seemed just overwhelming. And never once did Jason blink, and never once did he hesitate to move forward and get stuff done. And you know, it's unfortunate that for personal reasons he couldn't take on the permanent position. But at some point we need to fill that. And you know, that's the only reason where we are right now. And I just want to thank Jason for his courage. And I know through the experience he's built up a lot of knowledge and experience that's going to help this agency in the years ahead. And I'm really looking forward to that. So with that, any other commissioner comments?
Yeah, Mr. Chair.
Sure, Commissioner Hall.
Well, I would just like to also publicly state what I've stated elsewhere, which is that I think Jason's performance ever since he took the job of acting commissioner has been excellent. I remember being kind of astonished at how completely professional and positive he's been with everything I've seen him do. He's had such a can-do attitude, and he's been such a pleasant person with everyone I've seen him interact with. I really don't know if I've seen a more excellently performing executive manager. And I too regret that he, for personal reasons, did not feel he could take the risk of becoming our permanent chief of staff. I would have wished that in a heartbeat, but he can't. And we have to, you know, look to the future of the agency. And and I think that we're bringing on a person who will be equally excellent. So I'm hoping it'll remain a win-win situation, and I hope we never lose Jason. And I think if we keep talking this way about him, somebody out there who is listening is going to try to steal him away, and I hope that doesn't happen right away. Anyhow, for our
I thought about that too.
So, but I really want to express my deep gratitude to Jason for being such an excellent person, a human being, to lead our agency through all these hard times. And so I'm glad he'll be staying. I'm comforted by the fact that I know he will be supportive of our new chief of staff. So, so I just want to extend a huge thank you to Jason as well. And we can proceed.
Okay, with that, Mike, would you please call the roll?
Commissioner Byrd,
Aye.
Commissioner Hall,
Aye.
Commissioner Vicente Aguilar,
Aye.
Commissioner Maestas,
Aye.
Commissioner Fishman.
Aye.
The motion is approved by a vote of 5-0.
Mr. Chair.
Thank you. Are there any final comments from folks before we end the meeting? And I'm going to just make one real quickly is I really appreciate this commission and how professional our commissioners, how professionally they conduct themselves. And it's over the past number of months, it's been a real source of pride for me. So thank you to all my colleagues.
Mr. Chairman, if I may ask Mr. Wayne Propst, our Chief of Staff designate, to say a few words and introduce himself to the team and anybody else that's listening out there.
Thanks for saving my butt on that one, Joe. Wayne, please.
Good afternoon, Mr. Chairman and members of the commission. It's a pleasure and honor to be with you this afternoon. I know you've had a long day, so I will keep my remarks very briefly. I am humbled and again honored by this opportunity, very grateful as well. I do think, Mr. Chairman and members of the commission, that the focus today, while it may naturally be on me, is rightfully placed on Jason and the staff that you have at the PRC. In my individual conversations with you and our collective conversations together, I've been impressed by your commitment, your faith in the staff that you have, the job that Jason has done for you, and I can only hope to build on that, working together with him, you, and your fine staff there. So I'm looking forward to that. I'm ready to get to work. And I will see you at 8 o'clock on Monday, April 19th, if not sooner. Thank you, Mr. Chairman.
Wayne, thank you. We're excited, thrilled to have you coming on board. And just, we need all the talent we can get. And you're obviously a critical piece to help us move forward. So thank you so much.
Thank you, Mr. Chairman.
Okay, with that, are we ready to adjourn? I think we are.
Mr. Chairman?
Commissioner Vicente Aguilar.
Yes, it's Holy Week in New Mexico, Mr. Chairman. I would like to extend Happy Easter to every staff member that we have on board, and to my colleagues. Have a wonderful time with your family, social distancing, and taking extra care. Thank you very much, Mr. Chair.
Thank you.
Ditto.
Okay, we are adjourned.
Bye. Good job.